Good evening, ladies and gentlemen, and I'm about to play you uh, a tape from a hearing that took place in front of George D. Heinrich here in Eureka, California on May 1st, 2019. I want you to be very, very, uh, attentive. Listen to uh, some of the things that are being said. You know, I want you to listen to when she declares that they have clear and convincing evidence that it is that at this time they couldn't turn my child over to me. I want you also to listen. So when she makes the order that I can't take the baby out of the state of California. I want you to listen when they ask me about returning to Chicago. And then I also want you to be listening when uh, Deborah Avamars, this is the one who was acting as my attorney, and I start telling her, and she tells me that this judge is going looking for a 30-year warrant. And I start telling her about what's going on. And last but certainly not least, I want you to be listening very, very carefully when I talk to her about already having a conversation with her about the baby being hurt, and she was supposed to go in there and tell that judge. So either she did or she didn't. Instead, whatever the deal is, I guess it didn't make much of a difference to that court or these people. So stay tuned. Listen, we're inside the courtroom. I'm not going to repeat myself. I'll just keep it court finds that the department did not solicit or integrate input from the child, mother, or father for reasons that are acceptable as fully outlined in 29E. Mr. Anderson's previously been found to be the father, but I'll go ahead and make 34 again. The court does find there is a parent of the child because the child was not residing at the time of the events or conditions that arose that brought the child within the court with regards to assume custody of the child. The court, that's 35. The court finds by clear and convincing evidence that placement at this time with the non-custodial parent is detrimental to the child. The court would note the lack of cooperation and earlier comments that were made. That's 56. The court does order the child declared to the court as outlined in 1. Mother and father shall not leave the child from the state of California without a court order. That's 3. The court does order the caretaker control of the child be vested with the department, as outlined in 4. The court does authorize placement of the child in suitable foster care, suitable relative or non-relative extended family care. That placement is necessary and appropriate, as outlined in 5 and 6. Maintenance for the child shall be paid at the established rate, and the county is authorized to seek reimbursement, as outlined in 9. The court orders reunification services to father only. Certainly, the time frame is the mother comes forward, the service could be provided to her. That's 10, as modified. The court orders the mother is participating, but the presumed father to participate in evaluations as specified in the case plan in order to determine any services or placement of the child with the father. That would include remedial services that would be necessary before placement could occur. That's 16. The court does order the parties to file the case plan. The court finds the case plan is appropriate and reasonable to allow the parents to rectify the problems that brought the matter before the court, and also to allow allow the court to consider placement of the child with the father. That's 17. I am going to direct counsel to advise clients of Evidence Code 1228.1. Obviously, others counsel or Brian and I can't do that unless she makes herself available to them. That is 18. Visitation shall be ordered in the case plan. That's 19. Would advise the parents of Welcome Institutions Code that talks about the possibility of permanency planning and termination of parental rights if the patient does not occur. that's 22. What I will specifically say is, since the child is under the age of 3, and failure of a parent or guardian to participate regularly in any court-ordered treatment programs or to cooperate with services outlined in the case plan may result in the termination of reunification services at the 6-month review from the date of the disposition, but no longer than 12 months from the date the child entered care. As I said before, that 12-month date is December 12, 2019. That's 23. I would, to the ability that Mother's Council can authorize them to advise their clients of the right to appeal, would also advise, but I would advise Father here that you have a right to appeal from the decision of the court. You have a specific time to do so. If you do not file the request for appeal within the time frame, you lose the right to appeal. Ms. Abelard can discuss that with you in detail, and so if you wish to do so, you need to make sure you talk with her. That's number 25. Providers counsel will sign a piece of information is outlined in 27A2. Parents will sign consents for treatment if they don't, the department can. That's 27B1. Reported offices, findings, and orders as orders of court. That's 31. All prior orders not modified by today's orders being in full force effect. That's 32. We will schedule the 6-month review.
October 29th at 8:30.
That's our next day. Thank you.
All right, that inquires the father planning on moving back to Chicago.
Yes, I do.
So you speak with the social worker, make sure he advises of the location there, so that there can be arrangements made with Chicago social workers to evaluate them in other situations. That's all for today. Thank you.
So what does that mean?
The judge is going to property right now because you're concerned about some of the warrants that you have in other states. She wants to know more about your criminal history. She wants to know the child welfare services.
Yeah, no, she wants to be a part of this shit and let my baby up out of here. There is no felony warrant. She goes after that, I'm gonna sue her for libel and slander.
Yeah.
You okay?
So I don't want the county to hear what you're telling me right now, so let's walk this through. Just that's the attorney on the case.
Oh, really?
Yeah.
Okay, he was the attorney. Yeah. I'm gonna sue for libel and slander. Right now, this is what she's chasing around after, trying to say, whether, whatever, a felony.